Good morning, everybody. Thanks for joining us today. It's good to see a lot of familiar names coming through in the chat. I got a really good webinar this morning on understanding the Colorado POWR Act. So this legislation went into effect August 7th, 2023. And we wanted to spend some time discussing it through an HR lens and provide understanding of what the act is, officially known as the Protecting Opportunities and Workers' Right Act, as it drastically changes the landscape of Colorado's Anti-Discrimination Act and broadens protections for employees. So we'll focus on the details of the act today, provide an understanding of the new regulations, and also include how employers need to respond or take actions to comply with that act. Today, we're joined by our presenter from CPS HR Consulting, Jennifer Houston. Jennifer has 32 years of experience in human resources, management, leadership, and professional business experience. Ms. Houston has earned multiple certifications, including Employment Law Certificate and Certified Mediator through the Employers Council. She also earned certifications in Senior Professional in Human Resources, SHRM Senior Certified Professional, and SHRM People Manager qualification. Ms. Houston has written and conducted training on a variety of topics, but specializes in human resources courses, leadership, management, and employee relations in both private and public organizations. Passion is all things HR. Her experience is in a variety of industries, and it provides for in-depth professional training experience. So really excited to have her today. Before I turn things over, a few housekeeping items. We're recording today's session, so if there's any issues with your audio or have to step away, you will receive a recording of this webinar through Eventbrite, same way you signed up. Also be available on our website at csdpool.org/events. A PDF version of today's slides are available for download in the files box above the chat box. And speaking of the chat box, if you have questions throughout the session, please feel free to type them in. We will take them as they come through and also pause at the very end for a final Q&A session. So with that, I will turn things over to Jennifer. Thanks for being here with us today.
Absolutely. Thanks for having me, Alex. Good morning to everybody. And I just have to admit right off the bat, on the very first slide, I flipped workers and opportunities in the wrong spot. So, let's hope it's all uphill from here, right? So, today we're gathered to talk about the Colorado Protecting Opportunities Workers' Rights Act. As Alex mentioned, it went into effect last August, and we're going to cover some really major details that the POWR Act has changed, or it hasn't changed, but putting that into place has changed, like the Colorado Anti-Discrimination Act, really puts a different perspective and spin on the EEOC and their guidelines as far as harassment and discrimination as well. So we'll go ahead and get into it here this morning. So yes, today we will talk about the reason for the POWR Act. What was the legislative thinking when they put this into place? We'll talk about what the POWR Act is, and then the variety of changes that really impact you and all of your employees potentially. And then finally, we'll talk about what should Colorado employers do now that we have this new legislation and need to take action on it in various different ways. Okay, so again, where did the POWR Act come from? The Colorado legislator felt like when this bill went into place, they were focusing on Coloradans and their right to work in the state and how to protect them. So essentially it came down that all Coloradans should have an equal opportunity to succeed in the workplace and to be free from discrimination and harassment based on their protected status. When employees have a safe workplace that is free from discrimination and harassment, those employees are more inclined to remain in their job, and their employers benefit from increased employee productivity and retention. While many employers have made great strides in improving workplace environments by making them free from discrimination and harassment since the Colorado statute that was enacted way back in 1951 for discrimination and harassment, many employees in the state still experience the discrimination and harassment in the workplace, and that does result in mental, physical, and economic harm. And again, as this slide indicates here, really, we all want our employees and ourselves to be able to go to work, feel like we can contribute, be protected from discrimination and harassment, and really all around create a better work environment. That will really truly help employees to remain at work and to really focus on productivity instead of focusing on the issues that are occurring if they are being harassed or discriminated. So that's kind of the background as to where POWR started. And Also want to mention that, as I'm sure most of you know, Colorado has more protections above what the EEOC puts into place, as far as like protected classes and things like that. Colorado is more robust when it comes to the laws in general. And so adding the POWR Act on top of it has even enhanced that even more. So I do think it's really important that you make yourself familiar with the understandings of the POWR Act. Okay. Again, with legislative declarations, it is critical that employers engage in preventive and corrective actions to eliminate discrimination and harassment and ensure a safe workplace environment for all their employees. The Act establishes fines for noncompliance and empowers the state and local authorities to enforce the provisions of the Act. Courts should apply the law consistently to all workplaces. So again, when you have employees in Colorado, because Colorado has more enhanced laws that assist the employee or in favor of the employee, those are the laws that take precedence. Whenever there is an employment law that is more favorable to the employee, those are the laws that we turn to. This is where POWR Act is again enhancing that. So the legislature, based upon seeing the variety of discrimination and harassment complaints that have come forward from employees and businesses and working with, the Colorado legislature, they did want to put this in the power into place to really do things to help prevent employees, which I think, we can all get behind. We all want our employees, like I said, to be protected, but it did make some pretty drastic changes that we'll talk about today. So, from the public policy of the state, again, a little bit more background from why POWR was put in place. It really is to encourage employers to adopt equal policies to prevent and disincentivize illegal harassment and discrimination. I'm sure everybody has got some policies into place that help and protect our employees, but again, really to make sure that they fit the new POWR requirements, and we'll talk about that as we go forward. Encourage the free reporting, discussion, and exposure of discriminatory or unfair employment practices in order to better protect employees and discourage discriminatory or unfair employment practices. And finally, any attempts to interfere with the employee's ability to communicate about the report allegedly discriminatory or unfair employment practices are contrary to the public policies of the state. What this really is saying, again, have robust policies. Make sure your employees know about your policies. Make sure your supervisors understand that if a complaint does come forward, they have to accept that complaint. Don't shut it down. Don't dismiss it. Make sure that they're walking through the appropriate steps, and we'll talk about some of that. And then again, if anyone attempts to interfere with the ability for an employee to make a report, there are liabilities for that now as well too. So again, just more stringent around some of the policies that employers have to have in place. Okay, so in a nutshell, let's kind of break down a little bit about how POWR is affecting employers now and employees. Ultimately, it imposes far-reaching changes to the Colorado Anti-Discrimination Act, or COTA, and the Colorado employment law generally. It redefines the standard for harassment claims. That's a very important one. Sets stringent requirements on non-disclosure agreements. Adds marital status as a protected category under Colorado law, which is interesting. And new requirements on the storage of personnel records. And we'll go through and talk about all of those. I think as I was, researching even over the last year since POWR went into place, I think one of the main questions is, why do we need to have marital status as a protected category? And one of the answers, or that really has been predominantly come across, is employers aren't really sure. And I think, oftentimes, and as we've seen, when a law gets put into place, it will change over, the next coming months or couple of years. Sometimes it needs to be, revamped or redefined by case law potentially. And from a marital status, what really they're trying to do is say, if you are married or not married, you can't be discriminated against because of that. Now, employers can still have nepotism policies in their workplace. They can still have a policy that says a supervisor or manager can't be a manager over their family member, their spouse, whatever it is. You can still have that. Uh, but really, the marital status is about not preventing, or excuse me, not prohibiting somebody from being hired or promoted or terminated because they are married to maybe somebody in the same company or whatever that would be. But I will say, keep a heads up for that. Again, like I said, I don't know that that would be one that's really prominent for employees to complain about. And I think companies are still trying to figure out what that means. So and as Alex pointed out at the beginning, the effective date of the POWR Act was August 7th, 2023. So just about a year coming up with this new act. And it will be interesting to see, what kind of claims have come out since August 7th, 2023, if it has really altered or changed the court systems and complaints against that maybe Colorado has received or the EEOC has received as well. So the big one here is a really far-reaching change that POWR put into place. We've all been probably trained and know about, harassment and discrimination. One of the caveats from the EEOC is that it has to reach the activity or the behavior has to reach a severe or pervasive standard to qualify to be a claim. Well, not in Colorado. So Colorado has changed that. The General Assembly finds that the severe or pervasive standard of proof created by the courts to determine if harassment at work is a discriminatory or unfair employment practice does not take into account the realities of the workplace or the harm that the workplace harassment causes. The state rejects the severe or pervasive standard in favor of a standard that prohibits unwelcome harassment. So this is what employers were concerned about in reality when this came out. Employers were concerned that, we're going to start getting complaints right and left. There's going to be such frivolous things that we have to look into. And I've done some training on this, in the last year or so as well. And I've gotten a lot of questions from employees to really kind of understand where they might fit into this. So if they've had a complaint previously or still are experiencing a complaint, a lot of employees are interested in this as well, obviously for their benefit. Employers are looking at it as though you're tying our hands. You are, the legislature is saying that, we have to take every complaint that's frivolous or, this or that. Somebody doesn't like my hair one day, somebody likes my shirt one day, whatever it would be. That's what employers were kind of reacting to initially at this. And then Colorado has gone on to kind of add a little bit more information to define that. But again, because this is new, I think we'll kind of see where case law starts to define this more going forward. So again, if somebody has a claim of harassment, they no longer have to meet the severe or pervasive standard that the EEOC and the courts have put into place. Okay, so let's talk about then what does it mean? What does it mean to still have a discriminatory or unfair employment practice? For an employer to refuse to hire, to discharge, to promote, or demote, or to harass during the course of employment, or to discriminate in matters of compensation, terms, conditions, or privileges of employment against any individual otherwise qualified because of disability, race, creed, color, sex, sexual orientation, gender identity, gender expression, marital status, religion, age, or ancestry. So that's from Colorado. That's now part of the POWR law that changed the Colorado Anti-Discrimination Act. One of the things you'll notice, again, as I mentioned in here, Colorado has more protected classes than the EEOC does. So Colorado has sexual orientation, gender identity, gender expression, ancestry, creed, and now marital status. They go above and beyond protected classes of the EEOC. So again, Colorado has more protections for employees overall. What this policy means, what this practice means, is that Again, we all know we're putting policies into place to protect our employees, to protect ourselves as employers by making sure we're complying with the law. But in reality, this is a very important thing to train your supervisors on, your hiring managers, things like that, particularly in their course of doing their job, hiring employees, managing employees, etc. This is an important part of the Power Act for all employers to know. Okay, one of the other big changes in power, it has changed disability discrimination claims. So it has the Power Act has maintained that it's not unlawful employment practice to refuse to hire, to discharge, promote, demote a person with disabilities if there is no reasonable accommodation specific to the disability that the employer can make that would allow the individual who is otherwise qualified to satisfy the essential functions of the job. That is pretty much standard with what the ADA says, the American with Disabilities Act, what the EEOC looks at as well. That is pretty much standard. Here's where it changes now as far as the Power Act. So previously, the law provided that it was not discriminatory practice for an employer to take adverse employment action if there is no reasonable accommodation that the employer can make with regard to the disability. The disability actually disqualifies the individual from the job, and the disability has a significant impact on the job. Power Act has changed it to say the requirement that the disability had a significant impact on the job has been deleted. So, from an employer standpoint, it offers more opportunity for an employee to have maybe some gray area of what does it mean to have a significant impact on the job? Um, what does the job description say? What are the limitations the employee may have? What are the accommodations they are requesting? As we work through an ADA claim, we go through all of those thoughts. We start having those conversations. We start analyzing that information and really trying to determine, is this a potential disability situation or request, or does the employee have a claim as far as this goes? Everybody able to hear me okay? I think my Wi-Fi blipped for a minute. I think I'm okay though. So with the change there, removing that the disability had a significant impact on the job, um, it really allows employees that don't have, let's say, extreme disabilities to be able to potentially make a claim. If it's something minor and the employer won't work with them on an accommodation, or if they say the accommodation isn't something that works for the job, the employee might have more of an opportunity to say, I'm still qualified for that job and you're not working with me because my disability doesn't have a significant impact on the job anymore. So that does allow a little bit more room for the employee to claim. I think one of the common themes that we're seeing with the Power Act throughout is that it really does favor the employee. It really provides more opportunity for employees to make a claim of discrimination or harassment. And this has concerned employers. There's been a lot of, um, petitions and papers to try to change law. It might come that will happen, but right now this is where we're at with it. And again, like I said, I think case law over the next few years might help us to define some of this a little bit better and to determine what are the bottom lines or boundaries for employers overall. Okay, definition of harassment. With power, it has changed a little bit, and again has changed the Colorado Anti-Discrimination Act. So the definition is to harass or harassment is to engage in or the act of engaging in any unwelcome physical or verbal conduct or written, pictorial, or visual communication directed at an individual or group of individuals because of that individual's or group's membership in or perceived membership in a protected class. one thing about those legislators, they certainly make long sentences and pack a lot of information in that one statement. However, I will say this is pretty much similar to what the EEOC is saying as well. As we all know, if you engage in unwelcome physical or verbal conduct, if it affects the workplace, things like that, which we'll talk about. But essentially, they're really trying to define what it means to have harassment in written, even putting pictorial or visual communication in there is a new sort of theme. Again, because I think of the advancements in the workplace. Also, part of this came from the fact of, when COVID hit and a lot of people started working from home, the actual, amounts of claims for or harassment or discrimination really did dip. When you look at the stats from the EEOC, 2020 through 2020, I think the latest out is still at the end of 2022, I believe. Really, though, it took a huge dip from 2019 in the fact that people really weren't in the office. And so there wasn't that person to person harassment. However, more claims came through as the advancement of technology came through text, through messaging on Teams, through Zoom calls, through emails. So even if you're not sitting right next to somebody in the office, now there's more of a technical reach that harassers are using as well. So Colorado tried to define that a little bit more by putting specifics in there about what could be harassment instead of just being. Again, definition of harassment says, of which conduct or communication is subjectively offensive to the individual alleging harassment and is objectively offensive to a reasonable individual who is a member of the same protected class. The conduct or communication need not be severe or pervasive to constitute a discriminatory or unfair employment practice. That's the big kicker that we talked about, is removing that severe or pervasive, and specifically for Colorado to put that in the new regulation. That is very important to employees and to employers for different reasons. But let's back up and talk about a little bit how Colorado defines subjectively offensive to the individual alleging harassment. Again, so what that means and what Colorado is saying now is, I am the person, and it's up to me to determine, was that conduct unwelcome? Do I feel, like I'm being harassed? Do I feel that I'm being discriminated against? I have the opportunity to subjectively say and think through the fact that I might be experiencing harassment or discrimination. It's no longer, again, removing that severe or pervasive. It could happen one time and I could say I've been harassed. Where under the previous law, where it does look at the severe or pervasive standard, employers and employees had to look at what, how severe was it? Was it happening every day? Was it, really offensive? Was it something that seeped into the workplace and prevented somebody from doing their work? Has it been going on for months? Is somebody, participating in a variety of ways of or harassing somebody? No longer do they have to do that. Again, it could be one time. It could be a one situation, and it doesn't even have to be that severe. So previously, again, if we were looking at severe or pervasive, I'm going to use an extreme example here, but if somebody was sexually assaulted in the workplace, that would be so severe, a one-time thing would potentially result in a claim and could be defined as harassment. So now it doesn't have to be that severe. It doesn't have to be as severe as like sexual assault. It could be that somebody, laid a piece of paper on somebody's desk with a potential joke, or something like that, that could be that make that person feel as though they're being harassed or discriminated against. This is the biggest issue that employers seem to have around this, is that the case for a claim is no longer as definitive for an employee that they have to meet. It really does blur the line on what is considered harassment or not. All right, let's talk a little bit further, Ralph. So It is a harassment and violation if, and these are all the same that we've still had from the EEOC, from Colorado Anti-Discrimination Act. Submission to the conduct or communication is explicitly or implicitly made a term or condition of the individual's employment. So again, this is sort of it's kind of quid pro quo situation. If you do this, I will promote you. If you go out on a date with me, I will give you that assignment that you wanted. If if you don't sleep with me, I'm going to fire you. Those are very specific things where submission to the conduct is a condition of the individual's employment. That is the most likely claim that is out there. Obviously, I think, we're of an age where people know that they can't be so black and white when it comes to harassment and discrimination. Fortunately and unfortunately, people are learning that and they're becoming a little less overt in their behavior. Second part, submission to, objection to, or rejection of the conduct or communication is used as a basis for employment decisions affecting the individual. Again, employment decisions such as, do I give them a raise because, they again went out with me, or whatever the case may be. The third part is the conduct or communication has the purpose of unreasonably interfering with the individual's work performance or creating an intimidating, hostile, or offensive work environment. This is the more likely case for claims. And I'm sure, you've seen this potentially in your career and things like that, is that it's generally not the first two. It's generally overt to the employee, but it really is more about kind of manipulating the situation from a power perspective. And I'm not talking POWR, I'm talking POWER. Like there's usually a power situation happening in harassment. And this is often what happens is it just makes the person's life miserable. And again, now that the severe or pervasive has been removed, that doesn't have to happen continuously. We don't have to say it's been going on for months or years. It can happen one time, and the employee can potentially have a claim of harassment. So what does it mean to be unreasonably interfering? The nature of the work or the frequency with which harassment in the workplace occurred in the past is not relevant to whether the conduct or communication is a discriminatory or unfair practice. Again, this is the removal of the severe or pervasive. It doesn't have to be something that has occurred or gone on, like I said, for months or years. What matters is what the person who's being subjected to that behavior is feeling subjectively, and if they feel like they're being harassed or not. However, I will say this is a good part that the legislature put into the POWR Act. Petty slights, minor annoyances, and lack of good manners do not constitute harassment unless, when taken individually or in combination and under the totality of the circumstances, meet the standards defined in the policy for harassment. So again, if somebody walks by you and accidentally bumps against you in the hall, maybe accidentally, uh, you know, reached around and touched somebody in their breast or genital area or something like that, but they were like, oh my God, I didn't mean that. I just happened to be reaching. Something like that is not going to constitute harassment. However, as we all probably know, an employee can make that claim, and that is something that you should not ignore. It should be something that you look into and determine. I think with this law, though, and that petty slight, that language, I would recommend that you add that to your policies as well. I think that's really important to help employees and supervisors understand that the little minor things that occur that somebody might get feel subjectively that they're being, harassed or discriminated. That's really what the Power Act is saying, is that we're not talking about that. When we give you the broader arena to file a claim, we're not talking about these petty or minor things. Again, doesn't mean that an employee cannot bring forth a claim from that, and you should look into it. But that's kind of an opportunity for employees to say they've been harassed. Again, it's more of a sometimes a opportunity for you to look at your policies and add this language in and maybe try to train some folks on that. One of the things that employers have said as well, help us to define what petty slights mean. What does a minor annoyance mean? And I think what Colorado has come back and said is it may be different for every environment. It really just depends. Is it appropriate in maybe a restaurant environment from an employee perspective, but not appropriate in a professional work office? It could depend on the work environment in general. Okay, affirmative defense. Let's talk about what an affirmative defense is first. So that's a defense in which the defendant introduces evidence which, if found to be credible, will negate criminal liability or civil liability, even if it is proven that the defendant committed the alleged act. So again, if you have policies in place, if you got a claim and you did everything right, you investigated, you took action, you trained people, you can use that as an affirmative defense to say, even if one of our employees did commit harassment, we as a company did everything right. And, we took action against the employee, et cetera. That's a lot of times how employers use that defense when they do have a claim when they get to court. And it's a great defense. It really is. I mean, sometimes as an employer, you do everything right, and you cannot always control what your employees are going to do or how they're going to act. Well, the Colorado POWR Act has changed the circumstances in which employers can use affirmative defense. So employers now can only use an affirmative defense when the supervisor has harassed or discriminated someone. It cannot be peer to peer. It cannot be employee to vendor, employee to contractor. It has to be supervisor to employee. So what the POWR Act is saying is when an employee proves that a supervisor unlawfully harassed that employee, the employer may assert an affirmative defense to the harassment claim only if the employer establishes three things. The employer has established a program that is reasonably designed to prevent harassment, deter future harassers, and protect employees from harassment. Okay, essentially, you've got a great, robust policy. You have a great communication plan to say, here's how you report incidents or issues or concerns. That's what that box is saying. And then secondly, the employer has communicated the existence and details of the established program to both its supervisory and non-supervisory employees. Train your staff, put out policies and have them sign up saying that they have received those policies. Even if it's like, every couple of months, maybe put something in a newsletter to remind people of your policies on this or that. So, any way you can communicate to employees to create the environment that you do not tolerate harassment and discrimination. And then thirdly, the employee has unreasonably failed to take advantage of the employer's established program. This means that if the employee does not take advantage of your complaint policy procedure, if they don't, report it to anyone in the company, maybe they go straight to the EEOC and file a claim. This is helpful in that fact that the POWR Act is saying the employee has to take advantage of the employer's policies. That is a good thing for employers. That is one thing that I feel that the POWR Act has helped employers on, because the employee can't just run, willy-nilly to the EEOC and file a claim or whatever it is, because it will be kicked out if they did not follow the employer's policies, if they did not work through a complaint process, which, helps everybody hopefully to have the complaint or the claim solved internally and in-house versus the employee having to go file a claim outside with the EEOC. Again, employees have the right to do that, but I think this provides employers with the power to say, let's try to fix it internally. Let's do what we can. And to say, if we can't take action on it, we didn't know about it. That's why the employee is required to follow the policy. What does it mean to have an established program? An employer's harassment prevention program satisfies the requirements if the employer can demonstrate the employer takes prompt, reasonable action to investigate or addresses alleged discriminatory or unfair employment practices. The employer takes prompt, reasonable remedial actions when warranted in response to complaints of discriminatory or unfair employment practices. Essentially, if you get a complaint, you look into it immediately and you take action immediately if there's reason to do so. Don't, put it off if somebody gets a complaint and put it off for a few weeks because so and so's on vacation. Work ways or find ways to work around that and make sure that you are taking action immediately if you can. Sometimes, uh, this is the importance of training supervisors. Sometimes the supervisor gets a complaint, but they're not really sure it's a complaint. And so they maybe kind of sit on it. And then, 2 weeks later, when they're in their one-on-one with their manager, they mention it. That could be a concern under this established program guideline from the POWR regulation. So this is where, again, the importance of training your supervisors on what to look for, how to respond if they receive a complaint or concern, even teaching them like an employee doesn't have to come up to you and say, I have a complaint. I'm filing a formal complaint. I am, letting you know that this is harassment. Most employees aren't going to do that if they have been harassed or discriminated. So train your managers, your supervisors to look for those red flags, listen to what the employee is saying, and to take the action to tell the employee, what you're telling me is very serious and I need to take action on this. So training your supervisors, those frontline folks who might be the first to hear or see of harassment or discrimination actions is really important so that they understand. Okay, from a record keeping perspective, POWR has put some pretty defined guidelines on what it means to do record keeping for discrimination complaints. So, an employer shall preserve any personnel or employment record the employer made, received, or kept for at least 5 years after the latter of the date the employer made the record or date of the personnel action about which the record pertains, or of the final disposition of a charge of discrimination or related action as applicable. Ultimately, if you receive a complaint of harassment or discrimination, what their record keeping provision is telling you to do is to start taking that documentation immediately, and then you have to keep that record for 5 years after the final decision, action, whatever it is to be. So if you've experienced like an EEOC claim, sometimes that takes, a year or so after the complaint was initiated to resolve. And that is what the POWR Act is saying, is whatever that last act as part of the complaint, you have to keep that record for 5 years after that. Maybe even if the employee isn't working there anymore, you still have to keep that. Now, I think most employers would look at it and go, well, the normal record keeping requirements for employee records is, I think it's 7 years after their employment started. It might run into this and might cross those lines, but the biggest thing is to make sure you're keeping the complaint record for 5 years after the final action. Further, an employer shall maintain an accurate, designated repository of all written or oral complaints of discrimination or unfair employment practices. So often when an employee comes to you, make a complaint, it is verbal or oral. And then we may go back and say, could you put this in writing for us? You can certainly ask that, but it's not required of the employee to do that. So with the records that you have to keep, you have to include the date of the complaint, the identity of the complaining party if the complaint was not made anonymously. Sometimes we receive notifications like an anonymous email, or some employers have anonymous reporting software that an employee or program that an employee can make a complaint anonymously. So that's where they're saying if it wasn't made anonymously, if you know the identity of the complaint, you have to include that in the record. You have to also include the identity of the alleged perpetrator and the substance of the complaint. Now, this is the first time Colorado, and probably other states as well, have had a guideline or a procedure to tell us how to keep complaint records as far as discrimination and harassment. So again, make sure that you're looking at this whenever you get, unfortunately, if you ever get a complaint or of harassment or discrimination. Things to include in your personnel and employment record. Again, this comes from the Colorado POWR Act. This isn't like a suggestion that you're learning as an HR person. This is the act telling you what you need to include in the personnel or employment record as of August 7th, 2023. Any requests for accommodation from an employee, any employee complaints of discriminatory or unfair employment practices, whether written or oral. Again, if the employee doesn't put it in writing, you should be taking notes and putting that into the file. Any application forms submitted by applicants for employment. Excuse me. Other records related to hiring, promotion, transfer, layoff, termination, rates of pay, or other terms of compensation and selection for training and apprenticeship, and records of training provided to or facilitated for employees. I think that's an important one to remember because often employers may, if they have a hold a training session for employees, they just have employees kind of sign in, if they walk into the room, and then they just might store that whole sheet somewhere, in their files or anything like that. What the law here is saying is that any record where you do any training for employees, so you may want to think about at the end of a training session, providing a certificate to an employee and putting that copy in their file, or having them create a form where an employee, each person fills out that they attended the training versus signing in on one sheet. You might want to think about some of those things when it comes to record keeping. So again, something different than maybe we thought of before. As Alex mentioned in the beginning, I have 32 years of HR experience, and I've never thought about, if I have a group training, I just usually have a sign in, and I just store that in one of my files. This is something new I think all of us have to think about as well. Okay, the POWR Act has changed non-disclosure agreements really, in my opinion, that can cause a lot of liability for employers. So this is a really important one to look at. So one of the things that, let's talk about one of the things that POWR has done is that in requirement for enforcing a non-disclosure agreement, a provision into or renewed between an employer and an employee or prospective employee that limits the ability of either party to disclose or discuss any alleged discriminatory or unfair employment practice is void unless it complies with a list of stringent requirements which are detailed in the POWR statute. Along with that, severe consequences for the employer for a non-compliant NDA. So bottom line, do not enter or attempt to enter into any non-disclosure agreements without guidance from your attorney or an employment lawyer. Truly, that is my advice. The guidelines are so particular and so specific now when it comes to what an NDA can include. And I also feel, and from what I've been reading, I think that will continue to evolve over the time as well. I think that more employers and courts are looking at the fact that it might be punitive to have certain non-disclosure agreements into place, and I believe that this is the start of that changing. This is the POWR Act taking that step to make the change for employers as we go along. So my recommendation is, if you're going to do a non-disclosure agreement, call your attorney, have them do it. I think it's just really better to pay that money than to pay a fine and other potential, claims down the road for not following the non-disclosure agreement provision. Okay, so what should employers do? This is a lot of information. It has changed a lot of things for employers in Colorado. First and foremost, update or create, if you don't have one, your anti-harassment policies and establish a program that includes the reporting, investigation, and documentation requirements under this act. And I even recommend that when you update your handbook, your policies, whatever it is, I would call it an established program. I think that helps to define Specifically, if you're going to use that affirmative defense going forward, to be able to say we followed the Power Act, we have an established program. So I think you can call it your anti-harassment policy, and that it is an established program. I think it's important to list that from an employer standpoint. Second, I would review your job descriptions and update them to reflect the essential functions of the job, including physical and mental requirements. So oftentimes, we put together a job description, and it could change over time, or you haven't looked at it in 5 years, or whatever the case is. It's important to look at those job descriptions to really make sure that you have essential functions of the job, and that is what you're going to evaluate a candidate based off of. So can they do these? That really helps you when you're trying to work through a disability situation to determine what is an essential function and if the employee has a possible accommodation for that. Secondly, I think a lot of times we have physical requirements in a job description, such as, you must be able to sit for, hours a day. You must be able to lift 50 pounds regularly. You must be able to work out in the heat, things like that. You might put that in job descriptions, but now we're looking at what are the mental requirements. You might want to put in there something that says, you maybe it's a customer service position at a call center. Put in the mental requirements that you must be able to handle, you know, talking to even 80 people in an hour. You must be able to handle, the communication and the stress and things like that. I think that's important to update in job descriptions that we probably haven't looked at before. And again, that's because the reason for that is because employers and courts are seeing so many claims of mental disability, um, depression, etc., things like that, that reflecting in their claim that they have with an employer that their mental disability needs an accommodation. So third, I would say train all supervisors and non-supervisory staff on your updated definitions of harassment based on the power regulations. Counties, cities, whatever your municipality is, look at all of your policies, define that established program, and make sure it is looked at from a harassment-free workplace, and make sure that you train basically everybody. I do feel strongly in the fact that supervisors probably need to have a more involved training and understanding of the new regulations and even harassment and discrimination. And those are the main policies, or excuse me, recommendations from and the Power Act that employers can do. I see we've got a couple of questions in the chat here. Here, Rebecca says, are there any mental requirements that would be illegal to include? That's a good question. It would be probably determined if you looked at it from a standpoint of, is it an essential function of the job? So, for example, like if you were, maybe you have a police department, that you're working with. I think it would be appropriate, and it is appropriate to say you have to pass even like mental testing, that they have to go through to determine that they can handle the police work and handle the potential extreme situations that they're put in. So I think it depends on the job. And I would say really evaluate if it truly is an essential function. If it's something that you think would be helpful, but not an essential function, that may cross that line when it comes to somebody filing a disability claim, where that may be subjective versus objective, and it may be something that their doctor or their healthcare provider would look at and say, that's not an essential function of this job. Help me to understand why it's an essential function of the job. So I think first and foremost, it really depends on the job. And then secondly, to really evaluate, is it truly an essential function of the job, or can it be evaluated or looked at in a different way or different perspective? Another question, Mary, does this apply to only sexual harassment or harassment in general? harassment can be the form of non-sexual. Yes, it does apply to all harassment and discrimination across the board. So we're looking at, age harassment, race harassment or discrimination all across the board as well. I think we have a couple more coming in here.
Yeah, great. We do have 10 minutes left, so now's a great time to answer or type in any questions that you'd like to have answered into the chat box now. And so as we're doing that, we'll take any more and come through. And I think, Jennifer, you have something to say on class evaluation.
Yes, if you would, please, I appreciate it. If you would open up your smartphone, camera, anything, hover over the QR code and complete the evaluation, that would be wonderful. Again, my name is Jennifer Houston, and this was the Understanding the Colorado POWR Act. When you go into the evaluation, it asks you for the name, and my name is a trainer. Let's see, I have a question from Sandy. Do you have sample policies available to get us started? I probably do actually have some. Are you talking, Sandy? I'm assuming you're talking in general, like discrimination and harassment policies. Yes, I do have that. Maybe Alex, could I provide that to you, and you could
Yeah,
send it
and I can
out?
also, yeah, I
Oh,
can definitely do that. I'd also like to take this time too to just point out the HR resources that we have for CSD pool members. If you'd like to learn more about them, we do offer HR Helpline, which is a web-based portal powered by Xywave, and on there you could find HR sample policies that can go into a wide variety of subjects such as job posting guidelines, HR policies that you should have on hand. So I'd recommend checking out that webpage, letting us know if you'd like to get set up, and we can help you navigate to find those policies there. We also offer 10 hours of free consultations through CPS HR Consulting, and that's available for members, 10 hours free every year, and CPS HR Consulting can help with candidate screening, policy reviews, individual HR training.
And there's a question from Rebecca about help for training staff. I think as Alex just mentioned that there is an opportunity for CPS HR to train, your team that would be part of the 10 hours that you have available to use per year. We've got the training already ready to go. So we'd be happy to, work with you to get that taken care of to help train your staff too.
Yeah, and to follow up with that as well, we do offer members free training through Vector Solutions, and there's a lot of different courses on there that have to do with harassment training specifically, and that's free to our members as well. And then to also answer Teresa's question, the slides are available for download in that files box above the chat box, and we will be sending out this recording to everybody later today. And I see also we had a question from Yvonne that came through. I think we missed it. The question was, what about harassment from elected officials to employees?
Oh, yes. So your employees and everybody that works at your organization, what the Colorado Anti-Discrimination Act and the EEOC says above and beyond is that your employees should be free from harassment and discrimination from basically anyone they encounter doing their job, whether that be an elected official, whether that be a vendor, a contractor, a citizen that comes in. Really, what you need to create is an environment that's free from any of those situations that could potentially occur, and really take action if your employee is reporting that to you. I would say it gets a little sticky, I'm sure, if it's an elected official, but you still have an obligation to look into that, and you have an obligation to provide a harassment-free workplace to your employees overall. So, yeah, even if it's an elected official. And Donna asked instructor's name. My name is Jennifer Houston, like the city, Houston, Texas.
All right, we do have 5 more minutes. So if there's any other questions, these are really great ones that are coming through on this topic. So if there's anything else that anybody would like to have answered right now, we do have a few more minutes. Otherwise, please take a look at our resources and those links. If you'd like to get set up for any of those, you can send an email, and that's on those web pages also.
Well, Rebecca asked a really interesting question here. What types of consequences can a workplace give a non-employee for harassing employees? Oftentimes, that is, I've seen it go as far as a restraining order. I've seen cease and desist into place. You may, like, for example, if it's a vendor, maybe you've got a vendor that comes in, cleans, takes your rugs and brings you new one or something like that. I would call that vendor and say, we no longer want so and so to be there because this happened. You could do that with contractors as well. Oftentimes, it's just making a change in who is allowed to come into your place of business, or really having to potentially change vendors or anything like that going forward. Um, if it is something sticky, like an elected official, they are obviously elected. I would say you'd probably have to work with your town administrator, your mayor, city manager, whatever, to work on that situation if it would happen to be an elected official. But sometimes it does reach the level of uh, a criminal situation, or you may have to call the police and have someone removed if you have to do that. But ultimately, what you want to do is protect your employee.
All right, we'll give it one more minute or two for any final questions, and I'll just take this time to promote next month's webinar to our membership, which is going to be on our annual renewals, insurance renewals. So if you'd like to sign up for that in advance, you can head on over to our Eventbrite page there, and that's where we'll take any questions on renewal, how to prepare for it, what to expect this year, and that's our annual one. So we'll just discuss everything renewal related. All right. I've written the thank yous here, so that's a good sign. I take this time to also say thank you as well to, thank you, Jennifer, for presenting today. This is a really great topic, and we had a really great turnout today, too. So I think just being able to explain this information in this act has been really helpful to our membership.
Yeah, absolutely. Thank you for inviting me. I appreciate it. I love being here.
Awesome. Thanks, everybody, for joining us today for this month's webinar, and hopefully we see you next month. We'll go ahead and wrap things up a couple minutes early and get you out of here. So thanks again, and thank you, Jennifer.
Thank you very much.